the sorry, Mr. Lech.
I was just going to ask if we're going to be recording this session.
Yes, it's recorded as standard.
It is recording. Okay, I just didn't get a notification on my Teams that it's been recorded. That's fine.
Oh, right. Okay. Stuart, are we recording?
Yeah, all good. Yeah.
Okay, good. Right.
Okay, thank you.
Yeah, obviously the session is we discuss conditions on the basis that without prejudice basis that if ministers grant permission, these are we're discussing the conditions under which it should be granted. So we have Mr. Buchan with us. So what I suggest is that we deal first with the two transport conditions, and then we can release him and we can discuss the rest of the conditions. I think originally I said we would just go through the conditions from start to finish, but yeah, so perhaps if we start off, and I imagine the transport conditions might take up a fair portion of the discussion too. The transport conditions are numbers. Well, it's a bit difficult to say because they're the revised number 23 and revised number 24 in the list of conditions. And I do have a number of questions on if we start with condition 23. I do have a number of questions on that, but perhaps the way to go into this to start off with is just to ask parties to explain what their disagreement is, because I'm not quite sure. I've got track changes, and I can see whose track changes are whose, but perhaps it's easiest if someone can just explain the disagreement to me. Perhaps if Highland Council go first, and then Mr. Fitzpatrick, I assume you'll be speaking for Highland, or is it Mr. Finlay? I'm not sure.
Well, it's a team effort, but I think Mr. Fitzpatrick on this one.
Right. Okay.
And I may come in on transport generally, but on the transport conditions, it'll be Mr. Fitzpatrick.
Right. And then, Ms. Howard, you're speaking for the applicant on this, are you? Yeah.
I will be, yes. Although probably a lot of the discussion on traffic, I'll hand over to Mr. Buchan.
Okay, grand. Right. Good stuff. Right. So Mr. Fitzpatrick, if you want to go first, just explain how you see the area's disagreement here.
Okay. So as far as I'm aware, Clause J, we've requested that's retained.
That's the J that's been scored out, yeah.
In the main section, yes.
Yeah.
And that would relate to general construction traffic, including HGVs. Yeah. So not AIL alone, which is covered by the next condition.
Does this condition cover AILs generally too, or does it are AILs entirely regulated by the next condition?
That's my understanding, but it's not my full expertise. But yeah, that would be my understanding.
Okay.
So sorry, that's generally the construction traffic management plan conditions in the past have been very long, and they've been sort of swung between one and the two. But the standard conditions now that we have with the ECU standard conditions, the template that they've provided separates the two. So yeah, because the traffic management plan covers construction traffic, more general construction traffic, then that's why we've requested that J is included. Mm-hmm. I think yes. I mean H, I guess is self-explanatory. That's in our notes there.
This is, yes, it's just about to what degree mud and debris have to be kept off the roads. Yeah.
Mm. Yeah. And it's all very practical measures. It's all about the actual construction. So, and it's for road safety and road condition requirements. I think also that they wanted transport plan wanted us to make the comment that the impact on the road will be quite significant. Mm-hmm. And that will include heavy HGV traffic as well, and that the cumulative situation hasn't really been assessed. We haven't really been provided that with the submission so far. That's been included in the EIA, so that it would be necessary to include additional information to have cognizance of any cumulative impacts at the time. We understand it's a working document, but we needs once it's submitted as a condition to the Highland Council, it has to have the most up-to-date figures that so that our transport planning team can.
So when you're saying it, what are you envisaging? What is to be submitted?
It's figures for the cumulative movements as far as they're known.
And that would be under which part of the condition? Under condition M, part M of the condition, or 1M.
Yes. Sorry.
Right. Right. Okay. And yeah, there's nothing. That's all of the disagreement, isn't it? Is it?
Yeah, I think just want to make sure that we're covered for in terms of road condition prior to construction beginning and post-construction condition, just to make sure that that's covered. We understand it's going to get quite complicated if a few developments are happening at once.
Well, that's going on to that topic. So I just wanted to understand the scope of disagreement first. So I'll ask Ms. Howard: is that your understanding of the area, or Mr. Buchan, whoever wants to respond? Is that your understanding of the areas of disagreement, or is it?
Yes, that's my understanding, that the scored out JI is the main point of dispute, I think, between the parties.
Okay. Right.
And then the new paragraph M was added by the applicant, after the discussion at the transport session. And yeah, I don't think it's necessarily a point of dispute, but obviously it's a new paragraph that the council might want to comment on.
And can I just ask before we go on, what Mr. Fitzpatrick mentioned additional information being submitted under that condition. Obviously, it is possible to submit additional information in terms of the IA regulations. Is that what was being envisaged? Not
by the applicant, no. I think what we envisaged was just up-to-date details. We've got the assessment that's been provided in the IER as it stands just now. However, obviously, the situation is unknown. There's a lot of movement in the area. We don't know what will get consented, when it might get consented, and therefore it's not necessarily additional assessment that we think is required. It's more just the practical details of what will be happening at the time of construction and any sort of mitigation the applicant would propose at that stage to try and mitigate against it.
Is that how you see it too, Mr. Fitzpatrick?
Yeah, I think from our transport planning team, with discussions with them, they just have advised that really the quantum type and route extents of heavy goods vehicle construction traffic hasn't really been included in route, nor any sort of concurrent traffic has been included with the submissions so far. So therefore, really, they haven't been able to do a full assessment of impacts on the road. So at the time of submitting the construction traffic management plan for review as required by the condition, then we would expect that more will be known, and that as far as the applicants, the developers are able to, that they can provide that information as up to date. And the assessment really at that stage will then inform what mitigation will be required at the time of construction and delivery.
But in terms of, it sounds like you're not sure whether there'll be significant effects in terms of the environmental impact assessment regulations, in terms of cumulative effects. Or there has been a cumulative assessment done in the EIAR, and I don't understand the council to have raised any question about that until this stage. Is there maybe I'm misrepresenting the council's position, but I did have a read of the 23rd April report of this year, and there didn't seem to be any fundamental issues raised with the information on cumulative effects at that point. Obviously, we've had the condition session, we've had the transport session since then.
So perhaps I could help. As far as I'm aware, it's not additional information in EIA terms. It's simply the practical information to inform the plan that is not yet available. So we're not making an EIA point,
Right.
and it's not the information to be provided wouldn't be additional information in EIA terms. We didn't take part in the transport session advisedly, and we obviously have concerns about the conditions that need to be opposed, but we're not suggesting that the conditions aren't capable of dealing with the impacts. It's just in order to inform the plans that are going to need to be drawn up, they're going to need to take into account of the up-to-date information as and when it becomes available. And the information is not going to be all in the hands of the applicant. So I'm quite happy for you to take it from Highland Council that its concern is not in terms of information in terms of the EIAR regs.
And so let's just focus on that condition 1M. 1M for the moment. Then does that address Highland Council's concerns? I mean, just to go over the points that were raised in the cumulative session in the development. I mean, I think there was. I don't know if there was this feeling on the part of the council, but some of the objectors, Swig in particular, were arguing that there needs to be some kind of third-party management of different of the various different developments, or some kind of overall overarching management, whether that would be the council or Transport Scotland or some other person, because there were a number of things that we went over. So obviously a cumulative plan dealing with a number of developments would be a live document, so someone would have to keep it up to date. There are a number of people with different interests. You'd have to, the council and Transport Scotland and all the various developers, who out of those should be the person to keep it up to date. There's the question of allocation of costs if there's a number of different projects. I think actually that goes back to, there's a reference to surveys in, I think it's condition I, pre and post construction surveys. Well, I think Mr. Buchan in his evidence, and we can confirm this, Mr. Buchan, I think you'd mentioned the possibility of having rolling surveys and comparing those with construction programs of different developments in order to allocate costs. So presumably someone would have to manage that if that was to be done, and condition 1I wouldn't be sufficient. Because it just refers to pre and post construction. And sorry, Mr. Buchan, go on.
Apologies, sir. The comment I made in the hearing session was in relation to the wear and tear elements, and that's a possible way of attributing that, and that can be dealt with within condition in the text in point I. That gives the minimum, the start and the end process, but it wouldn't necessarily limit the applicant to undertake further surveys during the process. I think the cumulative elements.
It wouldn't limit the applicant, but there's nothing requiring the applicant to do. If a different arrangement was arrived at, or if it was thought a different arrangement was appropriate or necessary to deal with a number of different projects in which there were a rolling number of surveys, that condition there, the condition I, wouldn't cover that. It would just require a pre and post construction survey.
It would require it as a minimum, yes.
Right. Yeah. No, I understand that. Yeah.
Yeah. I was just going to suggest that I think clause M hopefully addresses the council's point there, because you are undertaking a viewpoint within that construction period of other projects that will be on the road network, and that at that point in time then you can review what those projects are, what their traffic effects are, how those elements will work together, and look at joint mitigation measures that could be undertaken, obviously to the satisfaction of the two road authorities there, and hopefully that wording there gives the local authority and indeed Transport Scotland, who I don't think are represented here today, but it would certainly give both authorities the reassurance that a review of traffic volumes where they're occurring on the network and areas of common mitigation could be delivered for the period of the applicant's construction process. And I hope that that would help allay some of the concerns that the authority has raised.
If I may add as well, apologies for if I interrupted. Pre and post construction surveys would be addressed as well in the Section 96 agreement that we've requested.
Well, I'm not sure if a Section 96 agreement can formally do that. That's why it's generally put in conditions. It's about Section 96 gives you power to recover costs, extraordinary costs of wear and tear, and that can be sorted out by an agreement. So I don't know if the agreement. Well, maybe you've got other powers to enter into agreements. So I suppose you do have power to enter into agreement for pre and post construction surveys, even if not specifically under Section 96.
As far as I'm aware, that our solicitors and transport planning would use that process to apportion. Can use that process to apportion costs as well.
Okay, so potentially a Section 96 agreement could cover a number of different surveys if that was thought was what was thought to be necessary after an assessment under condition 1M. Does everyone think that? Is there the other aspects of it where obviously there's a number of different developers, obviously I've mentioned different people who are responsible for roads or putting traffic on roads. There was a suggestion from third parties that there needs to be a single body dealing with information to communities. Is that something that's dealt with under this condition too? Can that be covered in condition 1M?
I think from my point of view, I think it is. Obviously this is a plan that's to be submitted to the council for its approval. So that allows for discussion between the developer and the council at the point of submission to make sure that the plan includes everything that the council requires it to do so. And certainly I would imagine, community liaison or other form of communication could form part of the, the mitigation that paragraph M envisages.
And could the council insist on developers working together under this? This is a cumulative assessment of this particular development, if you like. Does the mitigation measures that can be used to that can the council insist on developers coordinating their communications under this condition?
I think from my point of view, it's something we gave quite a bit of thought to sort of after the session at the inquiry as to when there was discussion about cumulative, how, a condition could address it. I don't think it, we would, it would be lawful or meet the policy tests for a condition to be attached to the Ben Aketil consent that required anything that was out with the applicant's control.
No, it's not. No.
Yeah, so I think where we sort of envisaged it working is that, the council is the common, denominator there, and presumably every other development would also be submitting their traffic management plan. So the council, if they require certain mitigation measures to be included as part of our traffic management plan, then presumably they could also be, required as part of the traffic management plan for developments, other developments.
So, Mr. Bracken, sorry. Go ahead.
No, sorry. On you go, sir. And then I can add a point after.
No, I was just going to ask Mr. Fitzpatrick, do you envisage? I mean, is that perhaps it's going further than I need to go in understanding the condition? But the question was asked in the transport session. So, do you see the council's role? Is it a role for the council in coordinating the various, for instance, the communication of the various developments if they're given consent?
My understanding is that the community liaison group will be for the applicants, the developers, to carry forward. That wouldn't be something that the council would be. It doesn't mean that it would exclude maybe the local roads team or anyone like that. But my understanding is that community liaison groups are not for the council; they're for the developers to implement and to communicate updates. I think, and it's set out in clause L of one of that condition, that is for the establishment of community liaison.
No, I see that, but if there's, does it make sense to have however many, if there, let's say there's 6 different developments, does it make sense to have 6 different community liaison groups established by 6 different developers? Or is not something that can be dealt with under this condition?
Well, it would need to be. Sorry, forgive me if I interrupt. I think we would need the standard conditions across the board suite of developments, so they need to be applied to all conditions for all to ensure that the coordination happens. The wording might need to specify that there's a responsibility for each developer to coordinate with all other concurrent developments at the same time.
Mr. Bracken, you've got experience from Dalmellington, from building South Kyle, and coordinating with. You think you mentioned coordinating with other developments there. Is that what happened? The coordination was done under similar conditions to this, or was this a specific condition requiring a cumulative plan?
The experience. Well, I'm not aware that there was a coordinating one there, because South Kyle did its own thing and then was followed swiftly by others. One thing that has been suggested is in other schemes is that one developer starts a community liaison group, and when their project is finished, if there's one that follows immediately or there's a minor overlap, then it's then chaired by the next developer and so on, so that there is a body that continues, assuming that the text within the planning condition is very similar. But the point I was going to make earlier was that if you were to find in favour of the proposed development and granted consent via the ministers, then the developments that follow that would obviously then have the Ben Aketil scheme as a committed development, and its traffic, but also its mitigation measures would then need to be taken into account in their assessments, and that would then project those elements forward where their construction period coincides with the construction period for Ben Aketil. So there would be some logical kind of progression of common themes anyway. I think point M there helps ensure that there's, and again, that could be a common condition clause, words along those effects could be a common clause for other projects in the area or within Skye that could ensure that process continues there. But I think there would be logically, through the way that the system works, kind of a common theme of mitigation measures that would be delivered on the ground.
Okay, so just so I understand that this essentially, Ben Aketil set that in development would set up certain arrangements in terms of, I don't know, in terms of communication, maybe a website, in terms of means
exact
of
road signage or
road signage,
you know, an information protocol, things like that. If you were to determine the project, and you know, then other applicants would then need to obviously factor those common mitigation measures into their assessments as they go on as well.
Okay, and by factor in, what exactly do you mean?
Well, in terms of their EIA applications, because they also have to take the traffic, but also the mitigation measures that other developments then bring in as well.
Mm-hmm. Okay, thanks. I know this may perhaps not what was in dispute between the two parties here, but it's useful to go into that for me. So in terms of what's in dispute between the council and the, so I understand essentially that condition 1M is agreed between the council and the applicant. Is that correct? Is my understanding correct on that?
That's my understanding. Yeah.
Right. Okay. Grand. So the areas of disagreement are first. Well, let's deal with the mud and debris first. Can we just set out why? Does it make a difference either way? I'll start with Ms. Howard.
I don't think this is a big point. I think we had changed minimise from keep all, just for a practical, whether you can guarantee that not any mud would go onto the road network, but it's not a big point, and we could concede it if necessary.
Okay. Ms. Fitzpatrick, do you want to comment, or is it as straightforward as that?
Yeah. Thank you, Amy. If you're happy, it's a standard condition. It's the standard wording that's always been used, so we prefer it kept.
Okay. And then I suppose the main point in contention between the two parties is about the identification of upgrades to the public road network to ensure that it's standard capable of accommodating construction-related traffic. So carriageway widening, edge strengthening, provision of passing places, these are all to be assessed, are they? So perhaps you could just explain what this condition is about, Mr. Fitzpatrick, and what you envisage this doing. Is it an assessment and then works?
Yeah. So to make sure, so essentially, council roads in rural areas are not designed; they're evolved. So they're not generally of a construction capacity that's able to take significant changes in construction traffic beyond what's already given. So really, we just want to make sure that that we're going in with our eyes open, and we know what the condition is and what needs to be done to make sure that the roads aren't going to fail, that they're going to be able to accommodate the additional construction traffic. So that's why it's set out in detail in Part J.
Mm-hmm. Mm-hmm. Okay. So I guess it's Mr. Buchan who would respond to that, or Ms. Howard. Yeah, Mr. Buchan.
Yep, certainly. So I think the reason that we're not particularly keen on this is that we're using an A-class road network. We're not using back roads, C-class roads, unclassified road network. These are all A category.
Just on that, there was mentioned, it's not in this condition, but in relation to condition revised number 24, the abnormal loads, about use of the Upper Fjordlig unclassified road. My understanding is that the abnormal loads go in from the A863, not from along a former crofting track. They don't go up the Upper Fjordlig road.
That's correct. So
yeah,
they don't travel up that road. And I'm desperately trying to remember the reference number, but on the site layout plan, it shows the proposed track going up to a point. Now, I did review the
The CD13, if you want to look at it.
Yeah, I think it's the U4876. The council's road adoption description for that road suggests that they adopt a distance of 900 meters, and I believe that where the new access track comes in is to the north of that limit, so it's not actually interacting with that public road. I don't know if that's of assistance to clarify that, but it wouldn't be on that public road element there, so it would be purely on the A road network.
Yeah.
There. So in terms of damage to the public road, that's already conceded by both parties that the Section 96 agreement would cover wear and tear to the public road. In terms of the road safety elements of it, that's also covered within measures within the CTMP anyway. And the council hasn't, to my knowledge, led any evidence that we would require lay-bys for general construction traffic movement within the Skye Road network.
Mm-hmm. No, Mr. Fitzpatrick.
Yeah, sorry, just to reiterate about parts of the council's A road network, single track, contains cattle grids, and the structure again it's evolved.
Surely none of the access roads being used are single track or have cattle grids.
From the top of my head, I don't remember that one, but
they're not.
But it's also with HGV traffic as well, so we haven't got the routes. We don't know what quarries or anything like that that's going to be used at this stage. It's not been confirmed, so we don't know what the routes are. So we just want to make sure that that information is contained in the final construction traffic management plan.
Right. Okay. So at the other end, where lorries are coming from. Right. Okay. Mr. Buchan.
So if we're looking at the routes connecting existing quarries onto the road network, then those roads have already been reviewed by very virtue that there's a licensed quarry operating on them. So the quarry is already providing stone to other uses within Skye and the wider area. So those small sections of road, if they are publicly adopted sections of road, are already covered by the very virtue that you have a licensed operating quarry on that. Just because it's potentially going to Ben Aketil, the next day could be going somewhere else, and those generally quarry roads are maintained by the quarry operators to a higher standard because they are exclusively used by large vehicles every day, 365 days a year.
If this condition isn't inserted, but condition M is inserted, presumably, or 1M, that the one on cumulative effect, presumably, I mean, it's written very broadly, that condition 1M. So presumably, if there were cumulative effects that required carriageway widening, edge strengthening, provision of passing places, road safety measures, traffic management measures, presumably those might be, that they might be identified in an assessment under condition 1M and then implemented under that condition 2. Is that, do I understand it right? If they're necessary as a result of cumulative effect.
Sorry, is that?
So if this condition J wasn't inserted, but an assessment of cumulative effects of the development indicated that carriageway widening, edge strengthening, provision of passing places, and so on was needed, then that could be assessed and implemented under condition 1M. Is that, do I understand, read that correctly?
So we're not supportive of the amendment to J.
Well, the amendment is just its deletion, isn't it?
Yeah.
Right. So well, no, I understand that point, and I'm just testing one other bit of evidence, which is one other aspect of this, which is if J wasn't included, but there were cumulative effects that required various works to be done to make the roads suitable for cumulative traffic, then condition 1M would provide for those works to be done, for the assessment to be done and those works to be done. Do I understand that correctly?
It's not my understanding that puts that onus on the applicant for this one. I think J is a bit more specific, that the onus is on the developer for this one. So, for example, the Torren quarry was mentioned in the EIA, and that's a single track road in places. And also the volume and intensity that's of stone haul for a development such as Ben Aketil is going to be much more than a local minor quarry using local roads. My understanding is that the B8083 hasn't been assessed, so our roads team are specifically calling for the inclusion of J.
That's the road from the Torren quarry, is it? From the quarry.
Let me just double check.
If it would be of assistance, it's the road from Broadford down to Torren Quarry, which is in a southwesterly direction. That said, if you were to use Sconser Quarry, it's directly onto the trunk road. But both are current operating licensed quarries that could provide stone for anywhere on the island that has been sent at any volume currently.
Well, yeah, subject to whatever limits they have, but presumably that's not material. Yeah. Sorry, were you going to respond, Mr. Fitzpatrick, or you?
Just that the conditions of the roads need to be understood really before commencement of development and before we start.
But what about?
We need to understand where what routes will specifically be used.
What about Mr. Buchan's particular point that these are A roads, and I've travelled them, and I'm pretty sure that there's no single track sections or cattle grids on them.
My understanding is that we're not supporting the use of Sconster for development at present.
Yeah, but I was asking you about Mr. Buchan's point that these are A roads that would be used to reach the site accesses, you mentioned in your initial answer that some A roads in Skye are single track or have cattle grids, but I don't think that's the case with these roads. I think the A850 and the A863 are both dual roads, roads with two carriageways, and I don't think they've got structures like cattle grids on them, not directly on them anyway.
Yeah, but I think our understanding is that the routes haven't been finalised or settled, so it's unlikely that they would be only using A roads.
Right. Okay. Right. So I mean the routes from the quarries and routes, they're not necessarily settled, but there is a condition requiring approval of the routing of traffic associated with development on public roads. Yeah, I mean, is there anything other than stone coming from the quarries that would be a concern?
So there'll be delivery as well of other aspects of the development that won't necessarily be abnormal load.
Or stone from quarries.
Yeah, I think it's the biggest culprit as far as our transport planning team are concerned is the stone haulage.
Okay. Well, I think we've taken that as far as we can. I'll unless anyone wants to say anything further on this. Nope. Okay. Is there anything else on that condition? Yeah, actually, there was one other thing I wanted to ask about. There's nothing here in this condition, or I think maybe I've missed it, but in the other conditions about the site accesses. Obviously, in this case, there's two different site accesses, and I suppose one might be used, or the other might be used, or both might be used. Does that need to be covered in specifically in a condition, just to say which site accesses are to be used, or is it? I suppose it's covered in the routing of all traffic associated with the development. Yeah. Okay. Right. Sorry. I'll move on then. Okay. The abnormal loads. So that's revised number 24. If I understand the disagreement between parties is essentially in that 1E, the applicant is content that there should be an assessment of capacity of any bridges on the route to cater for abnormal loads, whereas the council is looking for assessment of the road network, including carriageways, culverts, bridges, passing places and crossings on the route to cater for abnormal loads. Is that right? Yeah. Okay, so why should the assessment be limited, Mr. Buchan, to any bridges and not other types of structures on the road?
I think so. If it would be helpful, I think it would possibly, if the wording there was altered to structures, I think, because then that would certainly cover bridges, retaining walls, any culverts. I think that would cover a number of those elements there, and I would hope that that would be agreeable to all parties there, because it would be the structural element, bridge, a culvert, retaining structures, that type of feature that is generally reviewed. But when you put in an application in for an abnormal load permit, it is generally done through the what they call the SDAL portal, which is the Electronic Service Delivery for Abnormal Loads, and that goes to the various structure operators around the road network. So in this case, it would be the Highland Council, Transport Scotland's maintenance company, and if there are any private structures or railway structures in the network, on this case, it would be at the far end for Network Rail, and the pier would be the other ones that would be added in there. So it generally goes to those structural operators or interested parties on it. It doesn't generally go to anyone else, and we've never yet had one where it said, thou shalt look at the makeup of an A road as yet. So it does focus in on structures, and I wonder if the word structures there would help both parties.
Does structures do it for you, Mr. Fitzpatrick?
I think so. Yeah.
Great. Okay. I suppose I do have a further question. We did have a bit of discussion at the transport session on the removal of rock from some of the from the narrow parts through the cuttings. Is that something that needs to be covered in condition 2, or is that just covered by roads construction consent, or by section 56 consent, or under the Road Scotland Act 59? I can't remember.
I wonder, sir, if clause B covers that, where it says details of accommodation measures.
Right,
I don't know if that's specific, but in my head that would include any form of mitigation and would imply the need for the technical approval through Transport Scotland or the appropriate mechanism through the Highland Council.
Good. Okay. Well, does that cover this condition? Is there anything else left on this condition to talk about? Mr. Fitzpatrick? Is there anything
Yep.
you
No.
content with that? Good. Okay, well, let's release Mr. Buchan then.
Thank you
I
very
don't
much.
think there's anything else we need you for, but thank you very much again. So,
My pleasure. But thank you very much, sir. Good day.
Thanks, Gordon.
right. Okay. So we'll go back to the beginning and run through the conditions from the top. So it's 1446. Does anyone feel in need of a break, or do you want to press on? Nope, press on. Okay, great. Right. So actually, let's go right to the beginning and look at. There's various comments on the kind of principles in the introduction. Should we discuss those in principle? I suppose since they're there, we should maybe discuss them. So there is a question first. I don't know. The very first comment by Ms. Banfro, I don't know if you want to comment on it, Ms. Banfro. This I don't quite understand, but something was removed. Some Highland Council comments have been removed, I think, at the start of the. Is that, are we concerned about that?
Perhaps I can help. So,
right.
I mean, my understanding is that this introductory page was removed, and Highland Council wanted it back in.
Oh, right. Okay. Right.
So I don't think it's not a substantive comment in a sense. It's a procedural comment, but the purpose of keeping it in was really the next two comments where there is a difference between the parties.
Grand. Okay. Well, let's.
I think that's correct. I'll be told.
So, first is avoiding use of inclusive requirements. So, a scheme has to be that the drafting approach is that a scheme has to be approved. Do you need to have specifics about what should be approved within the scheme? Highland Council says sometimes specifics are a good thing, and the applicant says that it's sufficient just to have a requirement to approve the scheme. Is that characterises it? Does it?
I think just from when we prepared this note, it was just sort of provided to the council with the first draft, just to provide a bit of assistance rather than being some sort of binding document that was meant to be kind of included.
But it does deal with a number of issues and different conditions. So
this point here, I don't think we were necessarily saying that the conditions should never list what should be provided in a scheme. I think what we're saying is that if it is, then it should be definitive, and it should say the scheme shall provide and list. I think our thought when drafting this is that include says it should cover these things, but maybe some more, and I think that doesn't properly define the scheme. And I think what we're saying is if you're going to list what should be provided, then that should be definitive.
Ms. Fitzpatrick, do you want to comment on it?
And by definitive, just so that we're in understanding, you mean that should be a finalised list? It should be a maximum,
a closed list, yes. So a list with everything in it. Yeah.
Yeah. I mean, I understand, but I don't think it's always appropriate to limit, limit mitigation or limit information that can be provided. Basically, we're setting out a minimum that would satisfy a condition, and that's that should be helpful for all parties.
I think just from sort of our perspective, I think if it's not possible to fully define what the scheme should provide at the time of drafting the condition, that's when we've said we should leave it for the scheme itself to do that once it's submitted for approval.
Well, I suppose in terms of the practicalities of purifying a condition, would you not normally just go to the council and say, well, the condition requires this? What we've produced an EIA with various stuff in it that says roughly what we were going to do. Is this what you want? I mean, did you not sort of consult the council first on conditions that you're to discharge in terms of requiring a scheme to be provided? Is that not normally what happens?
That's not something that I'm normally involved in.
Okay, no, fair enough.
It would happen, but I don't have any.
Maybe it's more of a question for Mr. Letch. I don't know if Mr. Letch wants to comment on it, or perhaps Mr. Fitzpatrick in terms of his experience of discharging conditions.
it's not a happy experience. It's to limit the back and forth, really, and there can be a lot of that, and there are so many parties involved in the actual construction and pre-construction, that a document that says what's expected from the start helps all of those parties, whether it be contractors on site, or if new issues come up on once there's further survey works, once there's so I think it's just much more helpful for us if the detail is there and we can check it against, and then we can understand what the actual impacts will be and what the mitigation is through the condition.
Okay, I mean, I think, sorry, June, unless you want to come back, sorry.
There was just one other point I was going to say, that I know that this was a point of discussion when the ECU model conditions that were recently published were being prepared, and that I think that was a point that was made by industry, and I think on the model conditions the wording include was changed to provide, and I think that was applied throughout the model conditions just to try and be a bit more definitive.
Right. Okay, so either providing closed lists or providing of things that are to be done, or providing a kind of general scheme without details. Yeah. Okay.
Yeah.
I mean, I kind of understand both positions, but well, I'll have a think about it, and perhaps we can, if particular issues come up in looking at the conditions, then we can address them there. And the other point is about specifying bodies who should be consulted before discharging a condition. I don't know if we need to discuss that. I think in practice, I completely agree with, or in theory, I completely agree with not listing people who should be consulted. But in practice, I find sometimes the pressure is that they should be listed. So perhaps it's just to deal with it in individual conditions. Right. Unless someone wants to say something about it, and that you have a very strong opinion that you want to put that will persuade me otherwise. No. Okay.
I mean, I would add, sorry, if that's okay. We recognise that we can, as a council, consult whoever we want, if within.
Yes.
But whether we get a response because the name isn't mentioned in the condition is
right.
another.
Does it help you get a response? Right. No. Yeah. Yeah. That's interesting. Okay. Well, okay, noted. Right. Unless you want to come back, Ms. Howard.
No.
Oh, okay.
Thank you.
So going to Annex 1. Sorry, is there a comment on Annex 1? Is that?
Yes, there are.
What was that? Oh, right. Oh, I see. Right. Okay. No, that's fine. We talked about that. Right. Okay. So just looking at the description. So there's a couple of points in the description. There's up to 9 is Highland Council would like the up to be removed, and Highland Council would like to insert with a maximum blade tip height of up to 200 meters or up to 180 meters. I have to say, well, do you want to say something about that? I'm not sure.
Perhaps
I clarify my position first. That will shorten things. I think in terms of up to, does it not just mean? I mean, if you get permission for 9 turbines, it's just consent. It's just permission. It doesn't make you build 9 turbines. So, in a way, the up to is redundant, isn't it? It doesn't matter if it's in or it's out. Do you want to respond to that? Well, it's hard to start off with.
Yeah, no, I think I agree with you that it is implicit that if you get consent for 9 turbines, you don't have to build 9. I suppose including the up to just maybe makes that a bit clearer, but I don't think it's a big point that I want to say too much about. Okay,
fair enough. And Mr. Fitzpatrick, in terms of your edition or the council's edition, with a maximum blade tip height, if the blade tip height is dealt with in a condition, and if the council, if the applicant wanted to increase the blade tip height, that would take an application either to Scottish ministers or following the energy bill going through the House of Commons or going through Parliament at the moment to the council. So does it really matter that it's part of the description?
I mean, well, first of all, we would always say that the description should convey the substance of the development, which includes the tip height and also the number of turbines.
Mm-hmm.
I'm not sure if you weren't to, so for example, if Ben Aketil was not to install 9 turbines but to install 4, what that implications that would have for the Section 36 approval, whether it be incomplete, whether they're
well, surely they would have got deemed planning permission, so they would be implementing the deemed planning permission. Is that not right?
It wouldn't necessarily be a complete development. I'm not sure what that would mean.
Does that matter?
In some respects, I guess it can, and it doesn't. But yeah. But if it's going to convey the approval of the substance of the development, then I do think it should be in the description.
Mm-hmm.
To go back to your question, yes. So the blade tip, if it's in a condition, it could be dealt with by a Section 42 application. If it's in the description, it would need to come in for a Section 36 amendment application. So they're very different kind of processes.
Different procedures, but does that make a big difference practically?
Yes, because if it's a material change to the application, we have to go through the whole landscape visual impact assessment again. We have to go. Essentially, we're assessing a new application that has to go through the council scheme, be done under the council scheme of delegation as well. Mm-hmm. So I think it's.
But the energy bill is going to increase the. Maybe I've got this wrong, but the energy bill is going to increase the installed capacity at which Section 36 consent is required, isn't it? So presumably by the time that will have passed, by the time Ben Aketil's, by the time that's relevant, the question of whether, and it would be a Section 42 procedure that would be used. Is that not right?
Would that be applied in retrospect?
I don't think. Well, it wouldn't be retrospect. By that time, it would be prospective, wouldn't it? Oh well, maybe it's not. Okay, I'll have a look further into this. Perhaps it's not something to drill down onto at the moment.
So can I just raise something on the first point? Up to Highland Council's concern is that if only 3 turbines were built, say 1, 4, and 9. You would have a wholly different landscape and visual impact. The design mitigation would be completely undone. Whilst I take the point that if you get permission for 100 houses, you don't have to build 100 houses if you build 99 or 90. But the same implications don't necessarily arise. It would be, at least arguably, and I will consider whether I should make further submissions on this, arguably a different development if you simply had, in these circumstances, if, say, you only had 3 turbines. One can understand if it was 8 or 9 turbines, the difference may not be very significant, but you could envisage a situation where there are 2 or 3 turbines where the difference might be very, very significant.
After consent has been granted, and perhaps we shouldn't spend time on this point, but after consent has been granted, and the consent is implemented to build 3 turbines, and potentially more turbines might be built later. And is there any enforcement steps that the council can take to require the remaining 6 turbines to be built?
Well, it would only be if what was being built wasn't pursuant to the permitted development.
Oh, so you might say, well, this doesn't have planning permission at all because it's not.
Absolutely.
Right. Okay. Okay. Well, I'll consider those points. And Ms. Howard, do you want to add anything just now? Perhaps this is better dealt with in submissions.
again, I think it's just a preference, to allow that flexibility. I think that it would be extremely unlikely that the development would go ahead with 2 or 3 turbines. I don't think that's, a realistic possibility. But again, we just included the wording just, for that flexibility.
No, fair enough. Okay, right. No, I take your point. Okay, I'll move on. I think I understand the points there, and I don't think there's anything else. Oh, the internal transformers. I see this is something that's been added by the council, isn't it? What
So
I suggest.
Can I jump in? There's no dispute now. We're happy with the position of the applicant.
Okay, that's grand. Right. So just transformers, not internal transformers.
Yes, I think
Right.
both sides' preference would be for internal transformers, but if it doesn't transpire that that's an option, given the particular location of this wind farm and the circumstances, then it's not considered to be an issue that would justify a condition.
Yeah. Okay. Great. I don't have right. So, and if we run through the conditions, the section 36 conditions are all agreed. Condition 5 has been taken out. That's correct, isn't it? Yeah. Okay. So on to condition 6 is not a condition either, as far as I can see. No. Right. And so revised number 7. I did have a question about that, and that was, these matters seem to be covered in slightly different terms in condition 1 of the section 36 condition. Why do we need a deemed planning permission condition on commencement of development as well?
I think because of changes to section 58 of the Town and Country Planning Act,
Right.
there would be if there's no condition on the deemed planning permission setting out the period for commencement of development, I think a 3-year period would apply automatically.
Oh, okay.
And then it wouldn't align with the 5-year period for the section 36 consent.
Oh, okay. Oh, that makes total sense. Right. Okay, I see. Okay. Right. Should it be in the same terms as condition 1, or does that not really matter? It's slightly different. The part 1 is slightly different from part 1 of condition 1. It's written confirmation of the date of first commissioning, and then written confirmation of the date of commencement of development. Well, I suppose I'll have a look at that. I don't know if we want to go into that just now. There's no disagreement on revised condition 8, is there? No. Yeah, on revised condition 10, or revised number 10, that's the design of the energy storage facility. There was a bit of discussion of fire in the planning session of the inquiry. Just wanted to check. I guess when the design of the energy storage facility is proposed, it will be open to the planning authority at that point to consider, as well as, the requirements in point 2 of condition 10. It will also be open to the planning authority to consult Fire and Rescue Scotland on the design. So, and that just covers the point about that was raised at the planning session, that generally speaking, Fire and Rescue Scotland are consulted on design of battery energy storage. Yeah, so we're happy that nothing needs to be added to the condition for that. No. Okay, good. Micrositing, that's condition revised number 12. I think this is agreed between parties, but I did have a few comments on that. First, at the end of the first paragraph in point 1, it says any such micrositing is subject to the following restrictions unless otherwise approved in writing by the planning authority. I wonder if that is actually lawful, that tail piece, unless otherwise approved in writing by the planning authority, simply because that would seem to give the planning authority power to grant permission for something that hasn't been applied for first, and second, that hasn't been subject to EIA. Is that not right?
I can see the point that you're making, sir. And I think we would be happy for that wording to come out.
Okay, that's fine. Mr. Fitzpatrick, are you content with that too?
Yes. Previously, it's always had a clause that in consultation with the relevant consultees. So sometimes there's restrictions for peat or.
I'm not sure that gets you over the problem, though.
Yeah, but I think if we are talking about micrositing rather than siting,
but the micrositing is already built into the condition, so the micrositing is subject to a limit of 50 meters. I think is it in there somewhere? Yeah, no wind turbine mast, energy storage facility, or area of standing should be moved more than 50 meters from the position shown on the site layout plan. Yeah. So that's, if you took out that wording, unless otherwise approved in writing by the planning authority, you'd still have the 50 meters micrositing.
Yes. It is in the standard wording from the ECU, so
no comment.
I wouldn't want to I wouldn't want to make any comment on lawful. It is a standard. I don't. If we have other, if we consider it a material change, then we would have we may be requiring a new application. Sometimes we also have the non-material variation tool to hand as well. So
because
it can be a practical measure. It can be a very practical measure for us to, in terms of resource and so. And those are factors to consider as well, but I wouldn't comment on the lawfulness.
That's an interesting point. Yeah, I mean, could it be added maybe that the planning authority can approve a non-material change that goes beyond the specific measures set down, just so it's clear. I mean, presumably the planning authority does have that power if it's deemed planning permission, but I don't know.
So I would agree with you that the words as they are at the moment do fall foul of the sort of tailpiece jurisprudence, and Mr. Fitzpatrick point's a good one, but the power to make a non-material variation would exist irrespective of the wording of this condition.
Yes, that's true. Yeah. I mean, it existed before it was put into the Act. I mean, it just didn't. It just it was confirmed in the Act, wasn't it?
Yeah.
Okay, that's grand. My other question here was about, it says in 1C, it says no micrositing shall take place with the result that infrastructure, excluding floating tracks or hard standing, has a greater overall impact on peat than the original location. Now, I think that, so taking hard standing first, I think that would, allowing a hard standing to be moved so that it had a greater impact on peat would go against the advice from SEPA, and SEPA didn't object on the basis that there wouldn't be impacts on the conditions imposed that ensured there weren't greater impacts on peat. In terms of floating tracks, presumably the reason for having a floating track is to ensure that there isn't a significant impact on peat. So presumably, you could move a floating track to an area of deeper peat, but the impact itself, which is what the condition refers to, wouldn't necessarily be greater. So I would suggest just taking out excluding floating tracks or hard standing from that condition, unless someone has a strong view on that.
I can agree with that.
So perhaps it'd be appropriate to say here, if I can just jump in, that my understanding, and I think I alluded to this on the first day of the inquiry, that conditions that SEPA require or other bodies are now primarily between them and the ECDU.
Right. Okay.
And Highland Council, whilst it is happy to play a role in discussion of them, I don't think it's our formal position to agree or disagree with them.
Okay. Ms. Howard, I don't want to put you on the spot. If you want to deal with that point in submissions, that's fine by me.
Sir, could I just make one further point in relation to the point we just discussed about the unless approved in writing by the planning authority?
Yeah.
I totally take your point in terms of moving the piece of infrastructure more than 50 metres hasn't been assessed in the EIAR, but for some of them, such as no infrastructure will be moved within 50 metres of a water course, I don't think that necessarily has the same effect as moving a turbine, say 75 metres rather than 50. You could move something maybe only 10 metres from the original position, but it maybe encroaches slightly into the 50 metre buffer zone.
So if it's got no connection with the watercourses, there's no kind of it doesn't necessarily matter, does it? Yeah. Well, do you want to have another think about that, and maybe, I don't know, if you want to make a submission with the council, or make a submission, put this in submissions, that might cover it, and we flagged it up at least in this session.
Okay, thank you.
Yeah. There's another couple of points. There's also not just the question of deeper peat, but there's also the peat slide risk. So, I mean, I don't know how likely it is that any infrastructure will be moved into an area of greater peat slide risk. I think maybe the track to the south might, there is potentially possible that it might be. I don't know, but perhaps that should be covered in the condition too. And also, I think I've mentioned there are various cultural assets. Glen Haystall Farmstead and the River Carroy farmsteads and farmsteads and enclosure. Presumably, the condition should prevent micrositing towards those if they're anywhere near 50 metres from the infrastructure.
I know that was one of the points you raised, sir, and I think what our suggestion was going to be was for a separate condition for an archaeological clerk of works who would be required to approve micrositing.
Okay, that makes sense. Right. Okay. Yeah, I think that's mentioned in the schedule of mitigation as well, isn't it? Yeah.
Yeah.
Okay. Grand. Okay, so do we need to talk any more about micrositing? Well, it's only me who's raised anything, so I guess nobody else has got anything on micrositing. No. Okay. Then there's condition 13, which is the council's catch-all condition on mitigation measures. Well, perhaps if the council speaks to it, if Mr. Fitzpatrick, do you want to speak to this, and why do we need a catch-all? Is it not better in principle just to condition all of the mitigation measures shown in the schedule of mitigation individually, and then there's greater certainty?
Okay, yeah. So I've suggested this as it's again, it's in the ECU standard conditions. So
right,
yeah.
Okay.
So, I mean, if it's a process of removing, it's just a case of it generally being well justified. I mean, it doesn't do harm to bring the scheduled mitigation into one place so that it can be assessed under one condition. So I think really that's as far as I would argue for it. I wouldn't be. Yeah.
Right. Howard?
I think our position is just set on the table that it's not necessary that all the mitigation measures that are necessary to make the development acceptable have been incorporated into this table of conditions. The table of conditions has been prepared with reference to the schedule of mitigation, and everything that we felt that was necessary to be incorporated in has been addressed by condition.
Okay. Well, I'll certainly reach a view on it, but who knows whether the ECU might reach a different view from me ultimately. Okay, the planning monitoring officer. Now, I'll ask Barty to speak to us then, and obviously you've the council of the applicants mentioned a case in which such a condition was rejected. The council has mentioned a case in which such a condition was included. I have to admit that I have also recommended such a condition in a previous wind farm at Galtaclay. I went back and had a look, which was also in the Highland Council area. So, bearing that in mind, would you like to make submissions on why we should reject this condition, Ms. Howard?
Yeah, again, I think I'd probably just stand by the position that we put in the table. You know, the applicant has a legal duty when implementing the consent for it to be in accordance with the conditions attached to it, and therefore don't think that it's necessary or reasonable for a planning monitoring officer to be required to ensure that those conditions are complied with, as there's already that duty there. I don't know what the position was in Galtaclay, but certainly in the Sky reinforcement decision that the councils referred to, that wasn't a project that went to inquiry, so therefore the condition wasn't tested. And in relation to Strathoical, I don't think there's any discussion in the inquiry report or the decision on it, so that I don't know, but would maybe suggest that the condition was accepted, you know, by the applicant. And I think, you know, there's circumstances in which, you know, in my experience, certainly in relation to the Sky project, where a developer might accept a condition in order to get a position of no objection from the planning authority, or because there's not going to be an inquiry, just to, you know, get the consent issued and move on. So just because it's been applied once, you know, doesn't necessarily mean that it should be.
Okay. Ms. Fitzpatrick, isn't this the council's job? And you know, isn't it a matter for the applicant to ensure they simply comply with the conditions?
Of course, the responsibility to comply with conditions is always with the developer and the contractors. This is a very practical condition for the applicant to ensure that is indeed the case from a planning point of view. From unfortunately, the council doesn't have planning monitor officers. It's all coming down to case officers and our enforcement team. So it's just we suggest it as a practical measure.
Is there something more burdensome about this wind farm than others, or?
We always suggest it.
Right.
Yeah.
Okay.
And it is also, just to point out, it's a standard ECU condition.
Right. Okay. Okay. Well, I think that's probably as far as we can take it, unless anyone has anything else to add. So I'll consider it, and again, I may take a view, and the ECU might take a different view. So we'll just have to see. But hopefully, on my, I can give them set out the arguments at least. The ecological clerk of works. Now the disagreement on this. I'm sorry, it's gone out of my head. Can you just explain what the disagreement was here? Maybe start with Mr. Fitzpatrick.
We've just requested an environmental clerk of works, which just has a larger remit to for all like environmental.
How do you envisage the remit of an environmental clerk of works? Is that covering archaeology as well, or
no?
How do you see it?
They'll be specific for archaeology, but in terms of ecology and any other environmental requirements, I don't have specifics, unfortunately, but I know that.
So, it would just be useful to have an example of what an environmental clerk of works would do that an ecological clerk of works doesn't do. Just so I understand. Would water quality monitoring, is that something that would fall into the gap? or is that something an ecological clerk of works would do anyway? So anyway, I don't want to put you on the spot. I mean, I'll go back to Ms. Howard and say why are you opposing this condition? Or just
so I think to start with, I don't really have a strong view on whether the title's ecological or environmental. I think I've seen both used and potentially interchangeably. I think where we differ is in relation to the council's paragraph 1A.
Right. Okay.
Because this is where it defines, the duties of what the clerk would do, and I think it's the first duty that I probably would take issue with, that to
monitor
compliance with the commitments provided in the EIAR.
Right.
I think that's very wide-ranging. I don't think an EIAR is drafted in a way. It's a huge document that any sort of clerk could, look at the document and easily see what they should be monitoring compliance with. I think the condition that the applicants proposed that, lists the, the specific conditions that the clerk's monitoring compliance with would be a more precise way of doing it.
Okay.
And Sarah, if I could just add to that as well, I'd be happy for that wording to refer to condition 13 for the implementation of mitigation measures.
Right. Oh, hold on. So just if we go through, so instead of impose duty to monitor compliance with environmental commitments provided on the IA report, impose duty to monitor compliance with the requirements of condition 13. Is that right?
Yeah.
Okay. Right. And condition 13
in the implementation of
mitigation measures. Oh, right. Okay. Does that make sense to you, Ms. Howard? Well, you're against condition 13.
Well, I was going to say we've opposed that condition as well, and there's also probably measures listed in the schedule of mitigation that wouldn't be within the remit of an environmental clerk of works. In relation to
like
transport and archaeology, things like that. So the full schedule, I don't think should be referred to in the condition.
But if the standing your disagreement with condition 13, if condition 13 was adapted so that the duties of the environmental clerk, or the matters that were for the environmental clerk of works were specified in it, or if this condition was altered, condition 15 was altered to specify which of the matters in condition 13 were for the environmental clerk of works, does that meet that particular concern, I suppose?
Yeah, it possibly would, but I think I probably still remain of the view that the conditions listed, by in the applicant's condition, that does cover the matters that the clerk of works would be expected to monitor.
Right. Okay. And that's what. Okay. So that's the deleted bit, isn't it? Right.
Yeah.
So that says impose duty to monitor compliance with the ecological and hydrological commitments provided in the construction environmental management plan. Right. Okay. Right. I understand now. Okay. All right. Okay. Well, I think I understand where you both stand. Is there anything else needs to be discussed on this condition before we just move on? No. Okay. Right. Geotechnical clerk of works. Now, the applicant's not agreeing that this condition is necessary and that it duplicates the duties of the environmental clerk of works. Or I have to say, in the peat slide risk assessment, there is a requirement for a geotechnical specialist to be on call to provide advice if required by site conditions. I don't know if that's the same thing. It's hard.
Again, we received that comment from you in relation to the sort of additional conditions, and our suggestion was going to be an addition into the SEMP, which required details of the measures to avoid peat landslide risk as identified in the assessment. I appreciate you've not got that word in front of you just now, but I'm happy to submit that after this session.
Yeah, that would be. I'd be happy to receive wording if Mr. Fitzpatrick is happy to. If wording along those lines would be. It's not. I suppose again, it's not really Highland Council's thing, is it?
It's not a Highland Council
the high peak slide risk
concern. Yeah. So it was just, as we said before, it's removed from the standard conditions, and therefore we just request that it's given due consideration.
Okay. All right. Well, why do you consider that a geotechnical clerk of works is needed? We did review. I have reviewed the responses, and I'm happy for it to not be included because the SEPA hasn't requested it, and NatureScott haven't requested it. But as you say, in the Ironside for our report, so it may be that their request for a geotechnical specialist is covered by this condition, or you may be satisfied that it's covered by the under the construction environment management plan. I wouldn't disagree with that approach either. Okay. Right. Okay. Well, I think that covers that, doesn't it? So thanks very much. Construction environment management plan. I note the point about pH rich. Do we need to discuss it? I think it's a matter of definition, isn't it? And I can add a definition to the list of definitions at the bottom for pH rich along. I think your position, Ms. Howard, is that that's just too much, or whose position was it that was just too much detail?
Yeah, I think that was the applicant's position, that it was just getting a bit technical for the wording of the condition. I know it had been proposed that we just deleted that wording and left it to the scheme, but I think I had thought that had maybe been agreed by the council, but maybe I've got that wrong.
I think it's better to leave that in as a standard sentence in these conditions, but
right.
Yeah, I know previously in a conditions session that I've taken part of, the reporter didn't understand what was meant by that, and it's to rely on the council planner to understand what
it did seem a bit jargony to me, but I did think pH rich probably meant alkaline, so it would be better just to say alkaline.
It may be.
Right. No, it wouldn't be better to say alkaline, Mr. Letch. No. You were shaking your head.
Yes, sorry, I was shaking my head on that one because
all right, okay. You weren't addressing me, no.
No. Well, I mean, if I was, I have to give my my point of view on this one. pH rich or alkaline is exceptionally broad, and often the water you get out your tap will be alkaline, or even maybe a little bit acidic, depending on where you are. This really comes down to a point of pollution, whether we are demonstrating that, or we can demonstrate that we're not polluting, or we are polluting, and if we are polluting, we do something about it. But pH rich or alkaline is just way too broad, because that would mean that any drop of water that comes out of there that would have a pH of 7.01, for example, would all of a sudden, when it's actually completely fine. There's plenty of rivers in the country that would have a pH level of 8 or 9, actually.
Yeah.
So.
Right. But do you have a suggestion about what it should be, or what would constitute pollution in terms of alkaline?
Well, frankly, I wouldn't just have it there at all. Honestly, I know you could argue that would leave us, wide open to do anything we wanted, but I mean that's not the case really.
Site-specific details for management and operation of any concrete patching plant, including disposal of pH-rich water, waste, and substances. Well, as part of a management plan. Yeah, no, I take your point. I'll consider it. If it's in the standard condition, I'll have to consider it a bit more. But yeah, okay, take your point. Right. There's a number of other drafting points. Do you want to go through? I'm not sure I have a complete overview of them. Do you want to go through the points, your points of disagreement, Ms. Howard, on this condition, and then Mr. Fitzpatrick, what your points of disagreement are, and I'll try and sort through them.
Apologies if I'm getting this wrong. Let me just. I don't actually think that there are any more points of disagreement on the SEMP. I think the only change that's showing is paragraph N bullet
and that's
point,
agreed,
and that's been agreed that we can take that out, and there's another condition below to deal with it.
Okay. Yeah. And Mr. Fitzpatrick, is that your position too? It is. It's agreed. Is it?
There's just the more general point that we make that the construction environment management plan is, as far as we're aware and concerned, is a practical document for use by contractors and everyone on site. So if certain mitigation plans are included in the construction environment plan, then but are covered by other condition, then I don't think that's if there is some duplication, I don't think that's really a big problem, not from our perspective.
Right. Okay. And I've got some notes, but we've discussed the peat slide risk, and you're going to provide wording for me, Ms. Howard. And we discussed the archaeological assets, and you're going to provide wording for me. So I don't think we've got anything else on that condition. On condition 18, I just got a side note to say that this is a kind of pre-commencement condition, and it's not quite worded the same way as other pre-commencement conditions. It said, in other words, just because it says prior to commencement of construction of the energy storage compound. So I might alter that just to make it more consistent with other conditions. I think they talk about if I look for another one, so for instance, the previous condition, there shall be no commencement of development until a construction environmental management plan has been submitted. I think with specific parts of the with other pre-commencement conditions, there are similar wordings relating to particular parts of the development. So I don't imagine anyone will have any great concern about that. But
if I could, sir, I think our preference would be to keep the wording as it is, just because the energy storage facility might be progressed at a different point from the rest of the development. So that wording was proposed deliberately so that the development as a whole could commence, and that no work would start on the energy facility until that condition had been discharged.
All right, so there's a reason for having different wording. All right, well, I'll have a think about that. That sounds like I shouldn't interfere. Okay.
If I may as well, just to, I'm not sure if there might be additional refinement required just to include an updated construction traffic management plan. If there's additional abnormal load or anything like that, or HGV, so it's whether it requires its own construction traffic management plan, or if it requires
the energy storage compound.
Yeah.
Right, I see.
Sorry,
I suppose that's a reasonable point, isn't it, Ms. Howard? If a construction traffic management plan is needed for a battery storage facility, then if one is needed, then presumably it would be needed in this case. Is one generally needed for a battery storage facility?
We would generally get some kind of traffic management plan. I think also like with potential for cumulative impacts as well. So I think it might be that we just go away and make a suggestion for wording for that.
Yeah, do you want to have a think about it together?
Yeah, and
with the applicant council, that'd be good. Right.
Yeah,
okay.
No, I'm happy to have a discussion, and I don't think it's something the applicant would necessarily object to. My only point would be that my understanding is that a traffic management plan is usually a live document anyway, and could be updated, throughout the lifetime of that document if required.
Okay, grand. Construction details. Yeah, I just wondered, in condition or revised number 19 in construction details, this is about the phasing of the decommissioning and dismantling of the existing 12 turbines and the construction of the remainder of the turbines. There isn't formally a condition there requiring there's a condition about the time of commencement of dismantling of the existing 12 turbines, but there's no condition formally requiring the completion of their removal. But presumably that would be covered in the details that would be approved on the phasing. But perhaps a kind of backstop should be in this condition, just to requiring a certain number of years after commencement, all of the existing turbines should have been removed.
Yes, I would agree with that.
Does that make sense? It's hard.
I'm just trying to, in my head, work out how that would.
Yeah. So development shall not commence until the details of the phasing of the decommissioning and dismantling of the existing 12 turbines and their associated infrastructure. So that requires details to be approved of how they're going to be removed.
Yeah.
And in the event of construction scenario 2 being implemented, the period between the completion of the construction of turbines numbered 6, 7, 8, and 9 on the site location and the commencement of the dismantling of the turbines should not exceed 3 years. So the extension turbines can be built, and then within 3 years the existing 12 turbines have to start being dismantled. But there's nothing saying when their dismantling has to be completed. I mean, maybe that's not a problem, given that presumably you're building the repowering turbines, and you'd want to get rid of the existing turbines. But perhaps it would be sensible to have a backstop in.
And it could possibly refer to before installation of the repowering turbines.
Yes. Well, I suppose that's true. I mean, I suppose that would have to be the case. But it wouldn't be.
I mean, I think from a practical point of view, it would have to be the case. I think those turbines have to come down for the new ones, to go in place.
Yeah.
And I mean, I can foresee that there would be a scenario where they construct this side, remove this side, and it kind of meets. I'm not sure if that's a huge problem so long as it's happening.
Yeah. Okay. Well, I'll have a think about it. Sorry, I thought I'd better raise it, but I'll have a think about that. If anyone wants to make any further comment, then please do in submissions or in discussion between the council and the applicant. Okay. Construction hours. I take it from this condition that it's implicit that abnormal load deliveries, it's revised number 22, that abnormal load deliveries can be made at any time, and that's because you would want abnormal load deliveries to be made during the night, if possible. And that doesn't raise any issue, does it? No.
I think, since you've raised the point, sorry, it maybe would be helpful just to include that in the condition so that it was included in the list of activities that were permitted. Just for the avoidance of doubt.
Just saying expressly that abnormal loads can be delivered outside those hours, Mr. Fitzpatrick.
Yes, I just more of a general comment that and when it comes to construction noise or any noise complaint, it will be our environmental health team that would be dealing with that. So it would, regardless of whether it's permitted during a planning permission condition.
Well, they have powers in respect to statutory nuisance, don't they? Yeah.
So if it was a town and country planning application, we wouldn't impose such a construction hours condition.
Right. Really?
Generally, we wouldn't, because it's and our response in pre-app and all through and scoping is that the conditions aren't used to limit, because it's only it would only limit noise making activities.
Right.
So it's we this is one where it's our environmental health colleagues.
Okay. That's interesting to know. Right, but I think maybe we don't need to discuss that though. But I'll have a think about that. That's interesting. Right. Okay. We've discussed condition revised number 23, and we've discussed condition revised number 24. So you can skip over those. Habitat management plan, no. Regional monitoring and research. Sorry, I should have gone back to the IAR, but I did have a question on this, and presumably the reference to eagles means both golden eagles and sea eagles in that condition. Or perhaps you should just tell me to go back to the environmental impact assessment report and have a look at that and check.
I can go back and clarify as well.
That would be helpful. Right. Okay. Right. Okay. Condition 29 has been deleted. Condition 30 is the water quality and fish monitoring plan.
Again, I would just point out that this would be Marine Directorate rather than a Highland Council interest.
Right. Okay. So that's the only reason it's here. Right. Okay. And the applicant's position is that it's dealt with in the Kemp so
that's correct, sir.
Right. Okay. So I guess nobody's got anything to say on that then. Okay. So we'll just skip over that. And the program of archaeological works. Now you were going to produce further wording on a condition form, Ms. Howard, were you? Right. Do you want to say a bit more about that just now, or do you want to leave it for subsequent submissions or agreement with the council?
It might just be easier for parties if I put the wording into the table and send it to the council first to review, and then we can submit it to you, sir.
Okay, grand. Are you happy with that, Ms. Fitzpatrick? There's nothing you want to raise just now? No. Okay. Grand. Aviation safety. I've just got the note to raise about the Tyree on radar. Is that something you're just going to add as well, or is that?
In terms of the radar, an agreement has been entered into between the applicant and NATS, and NATS withdrew their objection in September 2023, and they didn't request that a condition was imposed.
Okay, all right. So I didn't pick that up. Right. Okay, grand. Presumably the agreement will kick into place if the development is constructed. And well, you maybe don't know the details of it. It's hard. No. Okay, right. Aviation lighting. I don't think that just requires lighting scheme. I don't think we need to talk about that. Site inspection strategy. Now this is a condition I've never come across before. So after 25 years, the council is looking for a condition that introduces a kind of site inspection regime for the last 10 years of the proposed development's life. And the applicant is not disagreeing with the principle of this. It's about some of the details. It's about the below ground infrastructure turbine bases. Is that right? That's the only point of disagreement here. Is that right?
The first point of disagreement is in relation to the first paragraph, sir.
Right. Okay.
Where the council require, as a pre-commencement requirement, a outline strategy to be submitted.
Right.
And the applicant's position is that's not necessary. We're talking about something that's going to take place, 24 years down the line. And I would also say that paragraph 3 already sets out what the strategy is to cover.
Right, okay.
And therefore I don't think that an outline
will help.
Is necessary.
Why is an outline necessary, Mr. Fitzpatrick?
I think we just generally have sight of such plans in any case. Same for the decommissioning and aftercare. And it's just to approve the principles. Obviously, any updated strategy will take account of best practice at the time. But it's just something that we generally look to have agreement with Nature Scott and SEPA from the start.
Never having come across this, I'm not really.
It's a new condition.
I've never seen one of these. But I mean, the reason I might ask for, in this kind of situation where with decommissioning plans, things like that, the reason I might ask for a kind of draft plan up front is at least with decommissioning so that you can cost what the bond should cover. Which isn't the case here, but second, so that you've got a kind of backstop, you've got a fallback if the condition isn't to produce a detailed plan isn't met. I don't know. I mean, would it make sense? I mean, if in those kind of circumstances, if just to produce a kind of fallback plan now for site inspection in 25 years' time. So that if in 24 years' time a plan isn't produced, that fallback plan can be used, or that outline plan can be used. I mean, is that an argument, Ms. Howard?
I mean, I wouldn't disagree with that. Sorry. But,
I think I would just point to paragraph 3, so that what the site inspection strategies to cover is demonstrating compliance with conditions, which are the noise and the appearance of turbines.
Right.
I don't know what you would say in an outline strategy to demonstrate that's something that you would deal with at the time.
Yeah.
Relevant to those circumstances. And then an engineering report, again, that's something that's prepared at the time. I don't think an outline, report would assist.
Right. Okay. And as regards to turbine foundations, is there a reason to check for turbine foundations, Mr. Fitzpatrick?
I mean, that would be beyond my expertise as a planner. Okay. I guess we're as far as we know, turbines, etc., have a operational lifespan of 20 and 25. So I guess for public reassurance as well as our own, we're seeking reassurance that these elements are safe and are being operated in a safe and careful manner. I mean, I guess I would point out that part 1 of the deleted part of is asking for a general strategy. It can go above and beyond anything that's pointed out in section 3, but I think, as you say, just to have that early on in the operational life is going to give reassurance to all parties that measures are in place to ensure that the continued safe operation beyond the 25 years of the lifetime of the turbines. I mean, turbine again, it is another one that's a standard condition now in the recently agreed ECUs, and that does include turbine foundations. Right.
I mean, again, it's not my area of expertise either. I mean, how would you check a turbine foundation? Do you have to dig it up to check it, or can you poke it or something? I don't know. Do some kind of. They must have in 25 years' time. Presumably, they'll have different technologies for doing that kind of thing. Mr. Lech, sorry, do you want to come in?
We can certainly inspect the elements of the foundation that are above ground. The anchor bolts where they connect with the foundations, but the parts of the foundations that have been backfilled on top of, No.
Right.
I mean, as I say, yes, in 24 years' time, there'll be AI robots that maybe I'll get down there and work out something. I don't know, but we would like to resist the inclusion of underground elements of site inspection in this particular aspect.
I mean, is there a concern that after 25 years, the stresses on turbine bases might cause a problem?
No. The construction of the turbines of the foundations are done using very very careful processes. The concrete that's poured is monitored, measured, and records are very well maintained.
So
older turbines.
So you're doing that kind of work anyway, or you're doing kind of some kind of monitoring of the condition of the turbine bases anyway, or?
Well, I mean, certainly during the construction phase, the concrete that's poured, the quality of the concrete is on every single batch that is poured. There are what's called cube tests or slump tests that monitor the particular mix of every single batch that goes in, and those records are kept for the life of the project. There are great warehouses full of cubes of concrete from all sorts of projects all over the world, but it's right to say that projects in the past, the turbine and constructions have been built with what's considered to be a 25-year life. Turbines were design certified to be for 25 years, design certified by Commander Lloyd or Diagnostic Vercast or whoever it may have been. But design certifications now for turbines are much longer. 35 years, and we would be constructing these with that kind of lifetime in mind. I'm not saying that we would continue to operate turbines for that long, or we may bring them down sooner than that. But the design certification would be for significantly longer than 25 years.
Right. Okay. And the design certification that's when you get to sue the maker if something goes wrong with them or
basically
the
yes. I mean, but the design certification is undertaken by an independent specialists. Right. The same sort of specialists that would be design certifying other power stations or oil refineries or pipelines or ships or whatever it may be. So, and the one of the lead bodies in the world right now is DNV, Diagnostic Vercast, and they actually a few years ago took over a company called Garrison, which is the leading wind experts in the world. It's likely that that DNV will be the design certification body that certifies the turbines, but it's the manufacturer of the turbines that gets those in. In fact, we wouldn't be able to buy the turbines or get them insured if they weren't design certified.
And is the design certification of the full thing once it's installed, or is it of the turbine that's being shipped to you?
Yeah, so the individual components of the turbine.
Right,
so, if we buy a turbine, in the turbine supply agreement, in the appendices, there will be the design certification process chart, and it will say that this turbine is certified to have transformers in it made by these three types of manufacturers, or have a gearbox in it made by these three manufacturers, right down to the little motors that turn the blades and the bearings that are used and all sorts of things like this. So every single aspect is known, clear, and understood that it makes it that particular turbine.
And is there a similar process for the contractor once in terms of the installation when the installation is done? Does the contractor certify that, or is that?
There's an independent engineer that will be monitoring the whole process, and that's required by our insurance as well. So that's something that we would be doing, and they have their own experiences for those particular matters as well. Yes. Mm-hmm. Okay. It's not exactly a design certification as such. However, the foundations that are designed are approved by the turbine manufacturer.
Right.
Because the turbine manufacturer won't just come along and put their turbines on any old piece of concrete. So.
Right. Yeah. Okay. Right. Does anyone want to say anything more about that? Right, Ms. Fitzpatrick, are you?
No, nothing much to add.
Okay. Right. I'll bear all of that in mind, and I think that's probably enough on that condition. Should we move on? Site decommissioning, restoration, and aftercare. There does seem to be disagreement on this, but what it is has gone out of my head. Just say.
If it helps, sir, the disagreement is in relation to paragraph 2, I think.
Yeah.
Where we define what will be included in the plan.
Right.
The wording shown in track changes is what's proposed by the applicant, and I think the council's position is they would prefer to revert back to the wording in the ECU standard condition.
Right. Okay.
Which I don't think we have a huge problem with, but with one exception in relation to the tracks, it would be the applicant's preference that a distinction is made in relation to the tracks. When it talks about the removal of the development, it's often the case, after a track's been in place for 30 plus years, that it would do more harm than good to remove it.
Right.
But we obviously appreciate the council's concerns that they want to have some control over what that might look like, and that's why the wording that we've proposed requires proposals to be submitted for the retention, removal, or other proposal. It therefore doesn't say that tracks should or will be retained, but it just allows the flexibility for proposals to be made, submitted to and approved by the council.
Right. Okay. Yes. I suppose the alternative would be, if you kept it as it was, the applicant could make an application for retention of the tracks at the end of the life of the wind farm. But does it make a difference? I don't know, Mr. Fitzpatrick. Is it not fine to leave it like that, and the council can approve or not approve proposals that are put forward under this condition?
Yeah. Generally, the tracks form part of the development, so and the tracks, if any are to be retained, they should be commensurate with the use that they are. And I think just our fallback position is we shouldn't, we don't know what they'll look like in 30, 35 years. They're generally wind farm tracks are quite huge scars on hillsides, and this is quite a sensitive area, and so I think it's just something that we should be assessing at the end of the wind farm's life.
Okay.
If turbines are to be removed, and if are we going to have tracks that lead to areas of hard standing, and what would they be for?
Yeah. Okay. Well, I think I understand your positions on this. Thanks for your help. But I don't, unless anyone's got something to say further, I'll move on to the next thing, which is the local employment scheme. Right. There's quite a lot of submissions on this. Perhaps we should have taken this a bit earlier. The way I understand it is that the applicant's view is this is not a condition that can lawfully be attached. Is that am I understanding that correctly?
Yes, that's correct.
Mm-hmm. Okay, and Mr. Finley's made a submission on that, referring to a number of cases, which I have to say I haven't read yet. But is there anything you want to add to your submission at the moment, Mr. Finley?
No, just that it appears to the cases, they're English cases, but the law is similar, where a similar worded condition has been approved, and they seem to have been referred to with approval by the Supreme Court. So there are two issues: is it lawful, and is it necessary? In this case, it's certainly lawful. Whether it's necessary in this case is obviously going to be determined on the particular circumstances of this case, against the background of MPF4 and maximising local economic benefits.
Perhaps it would help me if, I think it's probably easiest for me to deal with the lawfulness in terms of the written submissions that are being provided. I don't know if that's terribly easily sorted out just now, but in terms of the actual use of the condition, there's reference to local employment and the locality, but I'm not quite clear of what that means. Is that just something that would be defined in terms of the details that are submitted, Mr. Fitzpatrick, or is that?
I think generally, yes, we would look for the applicant to consider local, and for the condition what's been considered local in the submission in the AR.
Right.
So
might be slightly broader than locality for landscape and visual terms.
Yeah. Right. Yeah.
Sorry, sir. I think I'm maybe correct myself there. I don't think our position is necessarily to dispute the lawfulness of the condition in terms of Mr. Finlay's submission. That written submission is sort of a general submission on the legality of a condition. It doesn't refer to this condition or the circumstances of this case.
Right.
I don't know that we necessarily challenge that position. I think where our dispute comes in is probably more compliance with the policy tests rather than legality.
Right. Okay. So fundamentally, it's not necessary. It doesn't meet the other policy tests, or.
Yeah, I think in summary, our position is that it's not necessary to ensure compliance with policy 11C. Also, that it's not relevant to the development and that it doesn't relate to an effect of the development. The proposed development doesn't create a need for a local employment scheme, so it's not, it doesn't address an effect. And I think just one point I would make is that
doesn't that empty policy 11C of its effect? If the policy 11C is about maximising socioeconomic benefits, that there are other benefits that are secured by condition as well, like the ecological enhancements. Isn't it fair to secure benefits or benefits set out in the EIA by condition?
My initial sort of view on the hoof here is that when you're looking at the biodiversity enhancement plan, is that the development does have an impact on peat, for example, or generally speaking, developments have an impact on peat or on birds or environmental factors, and then there's mitigation and then enhancement.
Yeah, but you are mitigating, but the enhancement is a benefit on top of that.
Is a benefit. I suppose the other thing is noted in the table is that we don't have any guidance yet from Scottish ministers as to what maximisation should mean. And I would probably just point out that all, the Scottish ministers haven't required this type of condition on any consent that's come out post MPF4. And actually, I think they've rejected any attempt at such a condition. And the conditions they've rejected, or some of them are different and don't try to achieve what's been trying to achieve here. But in relation to Garvery Wind Farm, the applicant in that case had offered a supply chain protocol to be submitted to and approved by the council in that case, and the reporter recommended that was attached, but the Scottish ministers didn't attach that in that case.
Okay. I'll take a look at that. Did they give reasons why they didn't?
No, they didn't actually address it in the decision letter, but it's not a condition that's attached to the consent.
So I think Highland Council's understanding, as far as I'm aware, that the ECDU is concerned about the underlying legality of the principle of such a condition.
Right.
Which I'm grateful to hear is no longer in dispute as such. But certainly not in this appeal. But if the underlying legality is accepted or taken to be established, then it would come down to particular wording. And the relevance in planning terms will in part be established by the requirement within MPF 4 Policy 11C. That is part of, and you heard a certain amount about local employment during the socio-economic session, albeit Highland Council won't play a part in it. But that would be relevant to your consideration of this as well.
If I could, sir, just come back on that point quickly.
Sure.
In the examples where the Scottish ministers have refused to impose a condition securing socio-economic benefits, the reasons that have been given sort of either by the Scottish ministers or in the reporters' inquiry reports have related to compliance with policy tests, necessity, relevance to the development, relevance to the effects of the development rather than legality, as I understand it.
Right. Is there a particular decision I should look at in relation to that?
Mr. Bell refers to Bunloin wind farm in his evidence.
Right. I will have a look at that. Okay. Right. And the various amendments to the condition, to the removal of part 3 or paragraph 3, and the introduction of where possible in 2 and 3. That's a kind of a fallback position of the applicant, is it?
Yeah, that's correct. Okay. I think particularly paragraph 3, which was procedure for setting out criteria for employment, I think the applicant's position would be that it'd be unreasonable for the council to have, control over their own sort of procurement policies internally.
Mm-hmm. I mean, this kind of thing under EU law used to be discriminatory, or the issues used to be raised about discrimination, but I guess that doesn't apply anymore. Anyway, right. Okay, I don't know if there's anything further. We can take that any further. Right. Well, I'll just have a further look at that. And in light of any submissions that are made to. And the last condition is operational noise. And I only had one point about this, and that is that it refers to repowering and extension turbines. And I guess, well, I think it's clear what that means to me. I think it probably would be better to specify the exact turbines rather than just refer to the repowering and extension turbines. In scenario 1, so under operational noise, second paragraph, it describes the two different scenarios. So scenario 1, noise limits that apply to the repowering and extension turbines, and noise limits that apply to the extension turbines only if the extension is constructed before the existing turbines are removed. So just to say exactly which turbine numbers those are, rather than and the extension turbines I take as the ones that are to the south, and the repowering turbines are the ones to the north on the line of the existing turbines. Yeah, okay. And I suppose the way that the condition works, just for my information, just in case, I'm not sure if we don't have a noise expert here, but I assume that the the existing turbines will be subject to their own noise limits and their existing permission, and that's how cumulatively, the scenario 2 limits are set up so that it functions cumulatively. There isn't an unacceptable effect cumulatively at the receptors as a result of the effect of the existing turbines together with the extension turbines in scenario 2. Am I understanding that correctly?
That's my understanding, sir. Yes, that the limits for scenario 2 have taken into account the noise limits for the existing turbines.
Right. Okay. Good. Okay, that seems to cover it. Oh yes, sorry. There were a few other points that I raised that weren't covered, but you've dealt with the NATS issue, you've dealt with the heritage issue, the maintenance of public access to the site during construction. Are you going to cover that too in the further submission you're going to make on?
Yes. Let me just double check my note. Yeah, so I think in the EIAR it proposes that public safety during the construction period, will require the closure of certain paths, and safety signage. And I think the EIAR does propose that could be covered off in the SEMP. So I think my proposal would be just to add a line into the SEMP to cover that. That
sounds sensible. Okay. Are you going to provide that to me, or I'll try just add it in?
I'm happy to provide that in the draft that I'm going to prepare.
Great. Okay. Feathering or other mitigation measures for bats, I presume that could be added in too.
Yeah, I mean, the applicant's position was that a condition wasn't necessary for that. I think that, there was no significant effects predicted on bats, prior to the suggestion of the feathering that could be in addition. I don't think it was requested by any of the consultees. And I'm advised by my client, and I'm not very up to speed on the technicalities of it all, that if a turbine isn't in operation, the blades, as a matter of process and the way the turbine works, would be brought in and out of the wind. And I think when it refers to feathering, that's what it means, is bringing the blades in so that they're not a collision risk to bats, and that would happen, as a matter of process.
Right. Okay. Ms. Fitzpatrick, you don't have a comment on that, no? I take it you're not concerned about bats or feathering.
No, I think for the protected species would come this application would come under the remit of Nature Scope.
Right. Okay. And we've talked about the peat slide risk report, and that's grand. And there were a couple of points raised by Mr. Semler, which I think we probably covered, although he did suggest, I should have raised it before. He did suggest that his transport plan should be required to demonstrate that journey times for any journey carried out by a third party along the routes in question is not increased by more than 10% at any time. I'm not sure if that's a practical suggestion. I don't know if you have a view on that. I think we've discussed the other one, his other point about consolidated transport plan. But I think journey times would be covered in looking at in an assessment of cumulative effects of on transport, wouldn't it?
Again,
so I should ask someone in particular to deal with that. I think that's the case. Well, you drafted the condition as Howard, so
yeah, I think journey times might not explicitly be dealt with in the plan. The plan will be the routing, the measures that will be in place, the processes, the accommodation measures. That all affects, impacts on journey time. But I don't think that there's any proposal to put into the traffic management plan, a limit on what an increase in journey time would be, or what what journey we're even talking about, sort of thing. I don't think there's any proposal to include that.
Presumably the aim of the plan would be to minimise impacts on journey plans of other parties, journey times of other parties.
I've just been advised by my client that indicative journey times could be included in the traffic management plan.
Okay. Right. Well, that would make sense. Mr. Fitzpatrick, were you going to say anything?
What will I just we're discussing now the journey times of third parties impacted by construction. Yeah. I mean, I'm not sure what will it change. Having that knowledge, what would it? I mean, will it? I suppose it will update mitigation measures. Will it? I'm not sure what it's.
Well, I think Mr. Semler's view was that no journey time should be reduced by more than 10%.
Yeah.
I'm not sure if it's practical to set that kind of condition, because it would depend very much on the particular journey. Even as I'm not sure if you could even work out an average.
Sorry, sir, just to add that when I said there that indicative journey times could be provided, that would be for the AILs rather than third parties, because obviously
how long it would take the AILs.
Yeah, because obviously we would have information on, point A and point B of where the third party was going. So I don't know how you could. I don't think it would be possible to estimate journey times.
Okay, right. Well, I think that covers everything I was going to raise. Is anything else that we haven't covered? No. Okay. Well, thanks very much. Thanks very much for your time. Once again, that's all very useful to me in producing my report. We'll have a session on ornithology, and I don't think I've heard from the applicant yet on availability for ornithology. I think our window is looking like the last 2 weeks of August, given that beginning of September doesn't seem to be available. But perhaps you'll get back to me in due course on that, William Hurd.
Yes, sir. I'm just waiting for confirmation from a couple of people, and I'll confirm to Christopher as soon as I can.
Great. Okay. Thank you very much, everyone. That's perfect. Right.
Thanks very much.
Bye now.
Thanks, sir.
Thank you, sir.
Bye.
Bye-bye.
Goodbye. Bye-bye.